Hi, this is immigration attorney Mispa Chaudhary from Mispa Chaudhary and Associates Immigration Law Firm. Today is Thursday, April 23rd, 2020, and we are here to discuss the executive order duly signed by the President of the United States of America last night. And I will briefly discuss what is in the proclamation and how it is going to affect what kind of visas and what kind of immigration process. So first I will read the shall and shall not, who is included in there and who is not included in there. So there is a clarity about it. So it says that it shall apply only to the aliens, number one, are outside the United States on the effective date of this proclamation. Number two, do not have an immigrant visa that is valid on the effective date of this proclamation. Number three, do not have an official travel document other than a visa, such as transportation letter, an appropriate boarding file, or an advance parole document. Now it's going to discuss what shall not apply to. So first we discuss what whom it applies to, and number two, when what it shall not or not apply to. So number one, any lawful permanent resident of the United States. Number two, an immigrant visa as a physician, nurse, or other healthcare professionals to perform medical research or other research intended to combat the spread of COVID-19. Number three, an alien applying for a visa to enter the United States pursuant to the EB-5 Immigrant Investor Program. So it does not apply to the investors. Number four, any alien who is the spouse of a United States citizen. Any alien who is under 21 years of age and is the child of a United States citizen, it does not apply to him or her. Number six, any member of the United States Armed Forces and any spouse and children of a member of the United States Armed Forces. Number seven, special immigrant visa, which applies on the Afghani and Iraqi citizens. That is not applied to, subject to such condition as to the Secretary of State may impose and any spouse and children of any such individual. Number eight, would not apply in the it would entry would be in the national interest. So for the people who are entering United States based on the US national interest, it does not apply to them. So if we read and if we go through these shall and shall nots, it comes to a summary, it comes to a conclusion that this halt of immigration, that is the immigrant process of 60 days applies to the employment-based green card process overseas. So what it means is that the people for whom the US citizen companies and US citizens have applied for the employment-based green card, who are sponsors and applied for the employment-based green cards, and they are waiting around the world, waiting for their call or waiting for their interviews to get the visas and enter United States as the workers or as the work visas, as immigrant work visas. There is a halt on their process for 60 days. Anyways, how it's going to be implemented, because embassies and consulates are already closed and they are not conducting the interviews. So it is on halt practically right now. So they are giving the 60 days time period on that. Further, in the proclamation, it says that on the 50th day, if they will decide if they want to extend it. If not, it will end at the 60th day. So there is not much effect on any other kind of non-immigrant immigrant visas or non-immigrant stays or extensions or change of status or adjustment of status within United States. It seems to be implementing only on the immigrant visas and apparently on the employment base, basically immigrant visas for the people going through the consulate process. So there is 60 days right now. Let's see if there is any further advancement in that. If you have any questions, you can go visit our website, that is mispachaudhary.com.